Ready, start. It has been 37 long years since enactment of the Administrative Tribunals Act 1985 and establishment of Administrative Tribunal under Article 323A and 323B of the Constitution of India for adjudication of disputes in respect of recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the Union or of the state. However, despite availability of remedy of seeking adjudication in respect of service matters before the administrative tribunals, several writ petitions still continue to be directly filed before this court under specious plea that mere existence of alternate remedy is not a bar for exercise of writ jurisdiction by us under Article 226 of the Constitution of India. We have before us two such petitions filed by the candidates petitioner who are seeking recruitment to the post of Talathi in the Revenue and Forest Department of the Government of Maharashtra, Para. The petitioner in both the petition have participated in the selection process initiated by the District Collector Ahmednagar and Dhule for recruitment on the post of Talathi. The petitioner are essentially aggrieved by the action of the state government in publishing notification dated 15/6/2021 as well as issuing government resolution dated 31/5/2021 allowing candidates belonging to socially and educationally backward category to change the reservation category to economically weaker section category, thereby impining upon their chances of being selected and appointed on the post of Talathi. There is no dispute that the grievance sought to be redressed before us in the present petition is a service matter within the meaning of Section 14 of the Administrative Tribunal Act 1985. There is also no dispute that the petitioner have the remedy of filing application under Section 19 of the Act of 1985 before Maharashtra Administrative Tribunal which has jurisdiction to decide it. Para. When we express Mr. Sayyad, the learned counsel appearing for the petitioner as to how the petitioner can directly approach this court in respect of their cause of action which is admittedly covered by Section 14 of the Act of 1985 and in respect of which the petitioner have remedy under Section 19, numerous reasons have been cited before us urging us to entertain the present writ petition rather than relegating the petitioner to the administrative tribunal in view of the availability of an alternate remedy. Thus, Section 28 at one point of time excluded jurisdiction of even High Court with regard to the service matter covered by Section 14 of the Act. The question of validity of Section 28 of the Act of 1985 came up before 7-judge bench of the Apex Court in Learned Chandra Kumar Supra. The court held that Clause 2 of Article 323A and Clause 3D of the Article 323B to the extent they exclude the jurisdiction of the High Courts and the Supreme Courts under Article 226, 227 and 32 of the Constitution of India are unconstitutional. The court further held that the jurisdiction conferred upon the High Court under Article 226, 227 and upon the Supreme Court under Article 22 of the Constitution is a part of inviolable basic structure of the Constitution and that the same cannot be outstayed. The court further held that all decisions of the administrative tribunals would be subject to scrutiny before division bench of High Courts within whose jurisdiction the tribunal concerned falls. This is how the remedy of challenging decision of an administrative tribunal before the High Court came to be judicially created by way of decision in Learned Chandra Kumar Supra. Otherwise, prior to the decision in Learned Chandra Kumar Supra, the High Court did not even have jurisdiction to decide any matter covered by Section 14 of the Act of 1985.